Welcome to the Federalist Society's virtual event. This afternoon, Monday, February 12th, we will be discussing race at work. Can businesses treat people differently because of their race? I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and the Director of the Freedom of Thought Project, an initiative addressing new forms of coercion and threats to freedom of thought and conscience. In June of last year, the Supreme Court held that the consideration of an applicant's race in admissions violated both the Equal Protection Clause of the Constitution and Title VI of the 1964 Civil Rights Act. But many are wondering, what are the implications outside of university admissions? Today's discussion is the first in a series of programs we will be having to address some of the concrete questions that businesses, employers, and employees will be confronting following Students for Fair Admissions. We are delighted to have an all-star panel to kick off our webinar series. And with us to moderate the discussion, Judge Greg Katsas of the DC Circuit Court of Appeals. As always, please note that all expressions of opinion are those of the experts on today's call. And after our speakers give their opening remarks, we will turn to audience questions. So if you have a question, please enter it in the Q&A feature at the bottom of the screen. With that, thank you for being with us today. Judge Katsas, the floor is yours.
Thank you. So we're focused on diversity as a basis for race-conscious or sex-conscious hiring of employees or awarding of contracts. There is law in precisely this area. In the Weber and Johnson cases, Supreme Court held that despite the seemingly categorical prohibition on race and sex discrimination because of race or sex, Title VII actually gives employers fairly wide latitude to use race or sex-conscious hiring designed to eliminate what the court called manifest imbalances in the makeup of an employer's workforce. Are these decisions likely to be narrowed or overruled going forward? One reason to possibly think maybe is the Harvard case Alita mentioned. As everyone on this call no doubt knows, the Supreme Court last term struck down the race-conscious admission programs of both Harvard and the University of North Carolina as inconsistent with the Equal Protection Clause and therefore also inconsistent with Title VI of the Civil Rights Act. Harvard, of course, is not directly controlling on the question before us today. Harvard was about the Equal Protection Clause and Title VI, which respectively govern government action and actions by federal grantees. It's not directly about Title VII or 42 U.S.C. Section 1981, which govern employment and contracting respectively. And it also may be the case that the interests asserted in support of race-conscious and sex-conscious hiring and the diversity interests may be different in the context of higher education and employment. But the mood of the Harvard case is one of good bit of skepticism, obviously, of racial preferences, and that is something not really present in Johnson and Weber. Another variable in all of this that might bear on these issues is the court's change in its approach to statutory interpretation. Weber invoked a case called Holy Trinity to follow the spirit rather than the text of Title VII, and that might be a method of interpretation not really in vogue generally and not really in vogue in construing Title VII in the wake of decisions like Bostock. We've got a great panel to talk about these issues, so let me introduce them for you. Stacey Hawkins is a professor of law at Rutgers Law School and a nationally recognized expert on issues regarding diversity in employment law. She served on the Philadelphia Diversity Law Group and on the Pennsylvania Bar Association diversity team. Before joining Rutgers, she served as special diversity counsel at Holland and Knight and as diversity director at Ballard Spahr. She's a graduate of the Georgetown University Law Center. John Barry is the managing partner of Boyd & Gray PLLC and a former colleague of mine at Jones Day. He previously served as the regulatory policy officer at the Department of Labor and as chief counsel to the Trump transition in 2017. John is a graduate of Columbia Law School, and he clerked for Judge Jerry Smith on the Fifth Circuit and for Justice Alito on the Supreme Court. Jason Schwartz is a litigation partner in the Washington office of Gibson Dunn. He's co-chair of Gibson's Labor and Employment Practice Group, general counsel of the firm, and a member of its executive committee. He's also the co-author of a treatise on whistleblower law. Jason graduated from Georgetown University Law Center and worked as a legislative assistant to Congressman John Fox. Jay Edelson is the founder and chief executive officer of Edelson PC, one of the nation's leading plaintiffs' law firms, which has helped secure over $45 billion in verdicts and settlements on behalf of individuals, classes, and government entities. He's been actively involved in litigation over opioids, environmental issues, and consumer privacy, among other areas, and he's taught these issues as adjunct faculty at numerous law schools. Professor Hawkins, the floor is yours.
Thank you so much. So I always think it's helpful when we're having these conversations to start off by defining the terms that we are using so that we can all be on the same page when we discuss these issues. And often I find there is a tendency to conflate or to use interchangeably the terms affirmative action and diversity, but I think it's important to distinguish between those two concepts. And so when we say affirmative action, certainly traditionally, and I think still often, what we mean, and I think the kind of popular association with that term, is to the programs that really have their origins in the 1960s during the Kennedy and Johnson administration, programs that were really a response to the civil rights movement that were designed to remedy this country's long history of race and gender discrimination. And they were adopted by not just, public agencies, but also private employers that are contracting with public agencies, as well as eventually colleges and universities. And so those programs have taken into consideration both race and gender in an effort, again, to remedy the long history of discrimination and exclusion of certain racial and ethnic minorities, as well as women in higher education and in the workplace, particularly in terms of the workplace in the professional and managerial workforce, which is where affirmative action was most deployed. By contrast, when we say diversity, right, we're really referring to a much more recent practice that is designed not to redress past discrimination, but to achieve a whole host of instrumental goals deployed across a range of contexts, including both in higher education, where often colleges and universities talk about achieving the educational benefits that flow from student body diversity, and then in the employment context where there are a range of benefits that are articulated, but most notably, oftentimes businesses talk about a business case, that it really does inure to their kind of bottom line to effectively manage a diverse workforce. And so I think, with that backdrop, it's really helpful to understand how the Supreme Court has dealt successively with each of these two different contexts. Or concepts. So in two different cases in 1978 and 1979, respectively, the Supreme Court dealt with quote unquote affirmative action in both the higher education admissions and the employment context. And in those cases, the 1978 case was the case, Regents of the University of California versus Bakke, that's the higher education admissions context, challenging the use of race-conscious admissions by the University of California at Davis Medical School. And in 1979, the court decided the United Steelworkers of America versus Weber, which was an employment case that was decided around the consideration of race in the employment context at a steel manufacturer. And again, the Bakke case was decided under the Equal Protection Clause. So, right, we're talking about a constitutional claim that was being adjudicated. And in the Weber case, we're talking really about a statutory Title VII claim that's being adjudicated in the employment context. In both of those cases, the rationale, both on behalf of the University of California and on behalf of the kind of labor union and employer, in the case of Weber, were remedial, right? Both of those were really about traditional affirmative action. That is, both defendants said, what we are doing is we're trying to remedy the effects of past discrimination. And notably, both involved a type of quota program. I won't go into the details. If we have time or if anyone's interested, I'll talk about them, but a type of quota program in both cases. Now, interestingly, the court actually struck down the race conscious admissions program in Bakke, but upheld the program in Weber. And so a plurality of the court in Bakke rejected the rationale on behalf of the University of California at Davis of remedying past discrimination, because the court said the University of California at Davis had not engaged in its own past discrimination. And so the predicate of trying to remedy broad societal discrimination was not constitutionally legitimate. And so declined to accept that as a justification for colleges and universities engaging in race-conscious admissions. And moreover, said that under the Equal Protection Clause, quota programs are never permissible. They're never constitutionally permissible. But very importantly in that case, Justice Powell, writing only for himself, he signaled this alternative rationale that would later be taken up, and that was this diversity rationale. He said, while colleges and universities may not consider race for purposes of remedying broad societal discrimination, again, what we generally think of as affirmative action has been foreclosed since this 1978 case in higher education admissions. Instead, he suggested that colleges and universities might be able to use the consideration of race in admissions in order to achieve the educational benefits of student body diversity, if done not as a quota, but in this kind of individualized and flexible way that did not amount to kind of a fixed mechanical quota. Now, again, I mentioned that in the Weber case, the Supreme Court actually upheld the race-conscious program that really set aside about half of the training slots for a Black skilled tradesman in that context. Justifying this on the basis that it was not only, right, remedying past discrimination in a traditionally segregated job category, but there was this manifest racial imbalance in the workforce that was being directly addressed by this program. And the program, importantly, even though it was a little bit of a quota because it was half of the slots reserved for Black skilled tradesmen, it still nevertheless did not foreclose opportunities for the white skilled tradesmen. And so it was permissible. Later, the EEOC actually kind of codifies this standard in Weber that if there's a manifest imbalance and, right, there are still opportunities available, right, for white applicants, that will provide a safe harbor for engaging in what the EEOC called voluntary affirmative action, right? And so that is the Weber context. It is about voluntary affirmative action or redressing a manifest imbalance, traditionally segregated job categories in the workforce, so long as there remain opportunities open and available to white or, again, non-benefited applicants. In the case of gender, obviously, it would be men. Johnson is a kind of parallel case on the issue of gender under Title VII. It's worth noting, by the way, it's very curious because there is a direct kind of, parallel between Title VII and the Equal Protection Clause when it comes to race and employment, but there's not when it comes to gender and employment, right? So we have the Johnson case, which is kind of an analog to Weber in the Title VII context, but we don't have the same standard we know under equal protection for gender. And so that's kind of a different story. But if we fast forward to 2003, the diversity rationale that I mentioned was first suggested by Justice Powell in the Bakke case. It actually becomes the prevailing law when a majority of the court, 5 justices, actually vote to uphold the University of Michigan Law School race-conscious admissions program on the basis of the university pursuing student body diversity, right, so that they could obtain the educational benefits. And I think it's important to note that an important consideration that was expressly cited by the court in Grutter in endorsing the interest in diversity and the educational benefits that accrue is that they said, and I quote, "Major American businesses have made clear that the skills needed in today's increasingly global marketplace can only be developed through exposure to widely diverse people, cultures, ideas, and viewpoints." And I know because I was then in diversity practice at the time, many corporations view this kind of, what we would otherwise call dicta as an implied endorsement of their interest in pursuing workplace diversity at the time. Again, as distinguished from the kind of remedial Weber-based voluntary affirmative action that was being addressed in the Weber case and in other contexts. And so again, this holding was on behalf of higher education admissions, but impliedly, right, there was a broader recognition of this newer interest in pursuing the instrumental benefits of diversity, whether it is, having cultural competence and other benefits in the workplace context, or the educational benefits in the higher education admissions context. Now, of course, we know the most recent decision by the Supreme Court this past summer in the SFFA versus Harvard and UNC cases. The court reversed course and struck down both of those race-conscious admissions programs, as Judge Costa said. And rather than overruling that precedent, instead, Chief Justice Roberts, who wrote on behalf of the majority, he seized on kind of a reference in Grutter to a kind of 25-year time frame for the use of race to say that the time had expired for colleges and universities to be able to use race in pursuit of what still seems to remain, at least in the court's view, a legitimate end goal, which is diversity, but may not be pursued in the same race-conscious ways. Although in Chief Justice Roberts' majority opinion, he also notably said that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion, right, of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so often what I say is, colleges and universities may no longer consider the mere fact of a student's race, right? So there was a lot of discussion in the oral argument about kind of the checkbox that students complete on the application for admission and designate their race. And that was part of what was being considered in the admissions process by colleges and universities. That checkbox, information about the mere fact of a student's race, may no longer be considered, but that does not mean that a student's racialized identity and how they experience race is no longer an appropriate consideration in the admissions process. In fact, to the very contrary, Chief Justice Roberts indicated that that is very much still a permissible consideration. So much like in the higher education admissions context, we've seen the law move away from this kind of more robust endorsement of the remedial affirmative action rationale that was embraced in Weber. So the most recent case that the Supreme Court has decided on this issue was in Ritchie v. DiStefano in 2009, where the court seemed to suggest that there was a very high burden of proof, right, to establish the predicate for engaging in a voluntary affirmative action. Again, kind of narrowing the window for taking advantage of that safe harbor that has existed since the 1979 case in Weber. But again, it's important to distinguish between these voluntary affirmative action efforts that are designed to remedy past discrimination, which admittedly have become extraordinarily hard to defend and to justify under prevailing legal standards, and the diversity efforts that are widely endorsed and have been the subject of a lot of effort and even litigation. And so while the Supreme Court hasn't directly addressed the issue of workplace diversity efforts, I've done some research looking at the decided cases in federal courts, both district and circuit courts across the country. And that case law really does demonstrate that there is fairly substantial support for the interest in diversity as a legitimate non-discriminatory business rationale under the standard that is applicable to Title VII claims when an employer is not engaged in voluntary affirmative action. So if the employer does not admit that they are expressly considering race in order to remedy a manifest imbalance in their workforce and therefore subject to the Weber or Johnson standard, the default standard under Title VII is McDonnell-Douglas, this burden shifting standard where even if the plaintiff establishes some prima facie case, if the employer offers a legitimate non-discriminatory business reason for their actions, those actions are accepted by the court. And in the absence of some concrete proof of either pretext around those justifications or direct evidence of discrimination, the employer has prevailed in these cases. And so overwhelmingly, while I admit that the cases adjudicated under the Weber standard have fairly often failed on behalf of employers because it's an extraordinarily high burden to meet, those that have been adjudicated, even against diversity efforts under the McDonnell-Douglas standard, have found a very receptive judicial audience.
Thank you. John, you're up.
Right. Thank you, Judge Katsas. It's great to be here with you all. I see a couple of DOL veteran friends here, so I'll do my best to make you proud. We'll see. I want to start by I think signaling in large part my agreement with a lot of Professor Hawkins' account of the state of the law. The place that including that, yeah, we're seeing a lot of disfavor or tightening of judicial willingness to bless the more remedial, voluntary, affirmative action type plans, and it's a little more of an open question when it comes to non-remedial diversity rationales. I think where I may maybe start to depart is in looking first at students for fair admissions, and then next at my secondhand, I've not done firsthand survey of the lower court case law thus far on the diversity rationale, and then I'll go a little bit into the empirical business case as well. Right, as Judge Katz has pointed out at the outset, SFFA v. Harvard doesn't directly address Title VII, but I think what's really important to note here at the outset is that in the course of applying both the Protection Clause 14th Amendment as well as Title VI of the 64 Act, the court reviews Harvard and UNC's rationales for diversity programming in the higher education context that seem to carry over pretty readily to the workplace context. So, for example, the court specifically rejects as not sufficiently coherent for purposes of strict scrutiny the rationales under diversity of fostering innovation and problem solving, broadening and refining understanding, producing new knowledge stemming from diverse outlooks. All of those fail under the court's review, at least in that case. This was exacerbated, as Professor Hawkins pointed out, by the lack of time limitation on these, and that does get specific attention from the Chief Justice. The only immediate I think common justification for employer diversity programs that's not addressed is the phenomenon of call it customer demand, economic interest. But this goes back to Heart of Atlanta, where the Supreme Court there said that even if a business is going to suffer economic loss if it's prohibited to discriminate, that is of no consequence. So that's the backdrop against which I think we have to start assessing the ongoing viability of these diversity rationales in the Title VII context. On the question of lower courts, as I said, I've not done firsthand the case survey here. My primary point of reference on this is a case survey that Eric Dryband did. I published it last year, called just Title VII of the Civil Rights Act of 1964 and affirmative action, that looks at both the remedial and the diversity rationales, and concludes that where the courts have looked at this most directly, most prominently, a Third Circuit case called Taxman v. Piscataway County School District. There, the diversity rationale, a non-remedial diversity rationale, is squarely rejected by the Third Circuit. You have something similar from the Fifth Circuit in a case where Xerox was the defendant. And beyond that, I'm not in a position right now to go case by case, and I'm not necessarily disputing some of the upshots from what Professor Hawkins lays out, but I do think there is at least some reason, in addition to what the court has said in SFFA, to throw some real question on the availability of the rationale. More broadly, I want to identify that employers who want to push these types of race-based diversity initiatives are increasingly going to need to contend with the empirical disputes over what's presented as the business case for this type of diversity. It is often the case that the literature in this space is consultant driven or not rigorous. I want to say it was McKinsey that got the ball rolling on some of this. If you want a more comprehensive discussion of this, I would point to a literature review that Professor John Click, the University of Pennsylvania Law School, did that looked at a widespread array of the research purporting to associate increased, in that case, both sex and racial diversity with improved corporate performance, and tending to show that that association was just not demonstrated. But you don't have to take my word for it. This is also something we submitted on behalf of the Alliance for Fair Board Recruitment in critique of NASDAQ's board diversity quota rule. And indeed, the SEC, which I should add, by the way, this was under the Biden administration. This is Chair Gensler and a Democratic majority, concluded that the evidence on the business case for diversity was at best mixed and inconclusive, and the commission declined to rely on that business case for diversity in the course of approving the NASDAQ rule. So there's more to be said here, but I think it starts to get pretty complicated as we see more and more challenges to the diversity rationale against Title VII's apparently facial categorical ban on race discrimination. So I'll leave it at that for now, and I look forward to the rest of our discussion.
Okay, who's next? Jason.
Great, thank you, Judge. So I agree. I agree with both John and Professor Hawkins that this is a complicated mess. I think the best illustration of that is the reaction of office holders following SFFA, right? Like everyone's trying to explain what this means for the rest of the world outside of university admissions. You have these dueling statements immediately after the decision from the chair of the EEOC and a Republican commissioner of the EEOC, right? The chair says, this decision has nothing to do with employers or diversity programs, so carry on as you were before. Andrea Lucas says kind of the flip side of the coin. She also says this decision has nothing to do with these other programs at employers and otherwise because they were already illegal, right? So there is common ground between the chair and Commissioner Lucas, but you know, dueling conclusions. And then you have shortly after that, a letter from, I think it was 13 Republican attorneys general, many of whom have enforcement authority over employment and public accommodations discrimination, and sometimes contracting discrimination under sort of state versions of 1981. And the gist of their letter to the Fortune 100 CEOs is most of your DEI programs are unlawful discrimination, and we're going to prosecute you for them. A bunch of Democrat attorneys general respond shortly thereafter with a letter that says the following. The Republicans are wrong. The Colorado AG issues what I'm going to put in quotes, a legal opinion that says lawful diversity programs are lawful. Okay. And they say not only are the Republicans wrong, but if you halt these programs, you will then be at risk of engaging in unlawful discrimination. So all of that leads you, if you are sitting as a lawyer counseling corporations, to throw up your arms and say, what am I supposed to do? Right? Every choice is supposedly illegal depending upon who I listen to. What I want to talk about real briefly are kind of 4 key points that we have encountered in advising people on this work And just last week, I was in Miami arguing on behalf of our client, the Federalist Fund, in one of the leading 1981 cases post-SFFA brought by Ed Blum's organization, AAER. So that case raises a lot of interesting issues that I want to touch upon. So the four things I want to talk about are First Amendment arguments, Section 1981 arguments, what a case called Muldrow has to do with all of this, and then lastly, some practical approaches that people are following as they try to navigate the law is a mess, in development situation we have right now. So first, with respect to the First Amendment, for those of you who don't know, the Federalist Fund case is our client is a fund run by two Black women entrepreneurs who started both a venture capital investment vehicle, excuse me, and a charitable foundation, the Federalist Foundation, to support women of color entrepreneurs to help them overcome the discrimination that the founders themselves had faced in access to capital. The case challenges their charitable arm, and in particular, a program that gives $20,000 grants to Black women business owners 4 times a year, once a quarter, along with some mentorship. Our argument is that type of activity is essentially immune from a 1981 challenge, even if the eligibility criteria include race, because the giving of charitable contributions is recognized as a basically First Amendment protected speech, that for better or for worse, Americans speak with their money. There's a great historical tradition of different groups, whether it be immigrant groups or religious or ethnic groups, kind of helping themselves within their own community, and that type of giving is protected by the First Amendment above and beyond any discrimination law. Just as a fun little experiment, if you look at the United Way, you'll find hundreds of choices that are directed giving based upon race, gender, ethnicity, religion, etc. There's really good authority for this. Obviously, 303 Creative, I think you could make a very strong argument, suggests that expressive activity can overcome discrimination regulation. The Supreme Court has repeatedly said that giving of money is expressive activity. And then in our case, happens to be in the 11th Circuit, I argued there's an 11th Circuit case, a super interesting case called Coral Ridge Ministries versus Amazon, where Coral Ridge wanted to be among the choices that you could donate to in the Amazon Smile program. It's like, you go to the supermarket and they round up for charity and you can pick where your money goes, and Amazon chose not to include Coral Ridge. The 11th Circuit said that's a protected First Amendment activity. So that's the first issue is, to what extent are programs that are race-based but are charitable in nature or expressive in nature. So for example, some sort of socially conscious investment that is designed to empower Black communities or send a similar message of highlighting or combating discrimination, is that a protected First Amendment activity? I would argue, yes, it is. Second issue is, what are the metes and bounds of 1981, right? So on its face, it says you can't discriminate in contracting. First of all, a plain language reading of 1981 would suggest it doesn't grant rights to white people at all. It says all persons shall have the same right to make and enforce contracts as white people do. It was passed as a Reconstruction Congress effort to provide economic freedom to newly freed slaves, right? That even if they were technically free, you had all these white codes that prohibited them from owning businesses, transacting business, appearing in courts, etc. 1981 was designed to fight that. The Supreme Court in a case called McDonald said, notwithstanding the plain language of that statute, it actually grants everybody equal right to make and enforce contracts regardless of their race. One question is, if you were writing on a blank slate with a statutory interpretation based on plain language and even perhaps legislative intent, of the Reconstruction Congress, would you say that it covers quote unquote reverse discrimination? I think that's a real question. But in any event, McDonald says what it does. So there you're in that world. But then the question is, well, is everything that has a contractual element covered by 1981? Because again, if you look at charitable giving, it often has elements that look like a contract, right? You know, grandma gives money to the school and it's intended to be used for scholarships for students that cannot afford the tuition. They can't use it for the president's private jet, right? That would breach a quasi-contractual, if not contractual term of the gift when she checked the box for the scholarship fund. And obviously there are much more sophisticated versions of that from foundations, et cetera. Does that make it a contract covered by 1981? I would argue there's a very good argument that it's not. At the time 1981 was enacted, the Reconstruction Congress passes that. There are charities that existed then, including the Order of Tents, the Daughters of Africa, and even the congressionally chartered Freedmen's Bank that did exactly what my clients are doing today, right? Giving charitable giving to give economic freedom to communities of color that were discriminated against. It can't be that the Reconstruction Congress intended to outlaw those, or all of the things since the founding that charitable giving, the Sons of Italy, the Irish American Foundation, the Hebrew Free Burial Society, all of these types of charities that have existed over the decades can't possibly be illegal. There's a great statement in Town of Greece from the Supreme Court where they look at practices that were lawful at the time of enactment, in that case dealing with the religion clause, can't possibly have been outlawed by statute, that Congress knew they existed, did not intend to outlaw them. So that's a 1981 question. There's also, as Judge Katz has pointed out in the beginning of the discussion, Johnson and Weber have been applied under 1981, and not just to employment, but to other programs. Two super interesting cases, if you haven't looked at them. One is called Rabbani versus General Motors. Now, it's a district court case, so, you know, take it for what it's worth, but it is interesting. It deals with a GM program to provide car dealerships to minority owners that were underrepresented. And the district court there found that it met the Johnson and Weber test for a voluntary remedial program. There's also a Ninth Circuit case called Kamanahana School that deals with a school for Native Hawaiians where it wasn't a pure eligibility criteria, but it was a preference. And in practice, it operated to bar anyone except Native Hawaiians from enrolling in this particular school. So those are 1981 issues to look at. Third, Muldrow, you wonder what the heck is that? So if you read Andrea Lucas's writings and speeches, you'll see, and if you take a look at Judge Ho's concurring opinion in a case called Hamilton, an en banc case in the Fifth Circuit, you'll see the question in Muldrow is, where is the bar for a term and condition of employment that is actionable under Title VII? The reason this matters is lots of workplace diversity programs are not quite at the level of an actionable employment action. It's not a hiring, firing, promotion, change of status. It's a leadership development program. It's a mentoring program. Or in Judge Ho's example, it's a lunch program that's open only to women. Are those actionable under Title VII? Muldrow might reach that question. The reason I say might is I actually think there's a much easier way that Muldrow will probably get decided. Muldrow is about a police sergeant who is laterally transferred to a job that's less attractive because she's got to drive a marked vehicle, wear a uniform, and has less opportunity for overtime. It's kind of like, for those of you who like The Wire, when McNulty got sent to the boat detail in Baltimore Harbor. I think you can decide that case by saying what happened to Sergeant Muldrow was actionable without having to fully explore this issue of, you know, where does that line get drawn? But in any event, that's going to come out April, May, June, I think will be a significant watershed moment in the litigation of these diversity program cases. last point I want to make is just a practical one. So every employer in the country of any size is now reviewing its diversity programs to figure out which ones present risk and whether and how to make adjustments. Happy to talk to people about that offline. We also have a newsletter we publish every 2 weeks following all the litigation in this area. There's way more content than I thought there would be. And interestingly, I'm not sure if anybody else is doing this. So if you want to be on our list, it's free. Let me know. One easy thing to think about if you're looking at changing criteria is exactly what was alluded to by the professor earlier, and that is Chief Justice Roberts, what I would call the essay approach, right? Changing your criteria from your program to be expressly race or gender-based to a tell me about your individual experience, which might or might not have been affected by your race, gender, etc. But describe your own experience, obstacles you've faced, challenges you've overcome, etc. And that may lead to a similar place where you're removing barriers in the workplace, but with slightly different and safer criteria. So anyway, happy to talk about any or all of that. I think this is all fascinating stuff.
Jay, you're batting cleanup.
Perfect. Well, actually, I'm really glad to follow Jason's last remarks because that's kind of where I wanted to start. We're really in a unique time in society and in law where companies are kind of in trouble no matter what they do. So we've got really important stakeholders on each side, and they're both sides to this. There are people who firmly believe companies need to be more diverse, and others who firmly believe that doing so is a violation of the law. So what I know we're going to see, and it's easy to be in the prediction business when I'm plaintiff's lawyer because I know what suits are coming down the pike, is that we're going to see companies that are going to continue having diversity programs pretty much along the lines of what they're doing, but as Jason suggested, we're just going to mask it a little bit. So instead of actually looking specifically about your race, we'll just say write an essay about your background, and we'll use it as a proxy. And now I'm not putting words in Jason's mouth, but and I didn't mean to before, but they'll say we'll end up in the same place anyways. So that I think is going to lead to a lot of lawsuits, and I'll explain what lawsuits I think are coming. But then the ones that don't do that, who say, great, we actually never really believed in DEI, and a lot of companies didn't, and they kind of felt forced to do it. And they're going to say, terrific, Supreme Court has made it clear, we are done. They're going to be they're going to be left wide open to claims that their culture excludes minorities. Again, motivated stakeholders, there's going to be a lot of litigation on this, and I predict where you're going to have companies that are going to face opposite suits at the same time. Both you did too much and you didn't do enough. Okay. So that's just a rare, I've never seen that in the law before, and if that does happen, it's going to be fascinating. So first, I don't think we've got to be so circumspect about what the law is going to be. It's clear the Supreme Court has more to say about this, and it's clear how it's going to come down. So I think we at least should be honest that the idea that, and I obviously respect Professor Hawkins, but the idea that we're going to kind of rely a lot on former district court opinions and even appellate court opinions, I wouldn't find a lot of comfort in that if I was a corporation. I think that under Title VII, if you're using racial preferences, you're going to be in trouble, and that means in terms of hiring, in terms of promoting, and in terms of pay as well. However, I think it's also important to understand the lawsuits are not just going to focus on Title VII. People get really myopic, and it's like, there's one theory. So here's another theory that, again, I can be a good predictor because I know this is going to happen, and it should happen on Thursday. There will be a suit in the education context, which is going to focus on on fraud in how DEI programs were presented to potential applicants and to potential students. And the same thing could and the idea is you are saying to the public, we want a diverse, inclusive, equitable space. And you didn't actually honor that. And you can do the same thing in the employment context. And then you don't have to worry about Title VII. It's straight fraud. And the idea is, okay, I came to this firm thinking I was going to be treated equitably. And then I just found out, actually, I'm at this law firm and I'm a summer associate. And what other summer associates got, diversity scholarships where they're getting, $60,000 extra and guarantees of jobs and then extra mentorship and all of these other things. That is going to be a very direct lawsuit. It's going to be different than Title VII. And I think it's going to cause some interesting problems for companies. What I think this really comes down to is companies have to think about what are the goals of diversity. To me, first of all, there are kind of two goals, and I view things through the plaintiff's law lens. So I admit that I don't know other industries as well. For us, we are a creative firm, so we want to have a diversity of ideas, and having people from different backgrounds is very helpful. However, people stop, they put a period there and then they move on. But if you believe that, you have to extend that, because if you want diverse opinions, it's not just race and gender. It's also things like how people process the world, how people understand and perceive things around them, how they communicate, how they organize things in their head. To us, again, as a creative firm, that's more important than gender or race. But I'm not saying that means that they take priority, because we want as much diversity and creativity as possible. There also are more practical reasons to have people from different backgrounds, which is that you can end up having blinders otherwise. So, for example, the NFL concussion settlement, which was overall a very good settlement, the plaintiff's lawyers, I was not involved in this case, the plaintiff's lawyers who put it together, they didn't, I'm very, very sure they did not do this intentionally, but they allowed in the determination of how much individuals are going to get under the settlement. They had race norming, where they assumed that Black athletes started at a lower cognition level than white athletes. And because of that, the Black athletes got less in the settlement. The plaintiffs group was white attorneys, and it was not surprising to me that it was a Black law firm who came and said, hey guys, you didn't even think about this. And a huge part of the class got really kind of screwed over. Excuse my language, Judge. And that was fixed, and that was a really good thing. And the reason it was fixed was because someone understood these things happen to our community. I do have to also say, though, that I want to talk about remediation theory, which is, to me, that is a very, very dangerous road to go down. What I see is firms that embrace this theory of diversity, we should do it to help cure past harms. It ends up not helping anybody. So we all know that in law firms, especially big law firms, there are the diversity tracks where they hire diverse lawyers often. I'm just going to use law firms as an example. They hire diverse lawyers, and they don't actually believe in the 2 points I was saying, that having diversity of thought or background makes them stronger. So instead, it's just a numbers game, and they end up not investing in them in the same way because they don't think, oh, these are going to be great lawyers. That's an awful thing to do, ridiculously patronizing, and not good for the attorneys who are joining. I want to end with one other point, which is going to be perhaps a controversial one, which is I don't think it's true to say that diversity is necessarily good in every situation. And let's take the Dallas Mavericks as an example. I'm just a huge Mark Cuban fan, so I'm going to use him, even though he probably won't like anything I say about the Mavericks, other than that they're a great team. So my guess, if I'm Mark Cuban, is if I'm thinking about diversity, I'm thinking about it in two different ways. One is the organization as a whole, and then I want a lot of diversity in there. I want people from different perspectives who've got different ideas. I want people from different backgrounds who can think about different communities. All of that would function similar to how our law firm functions. But then you go to the actual players and you say, okay, is it really helpful to have diversity of experience and perspective for our NBA players? Or isn't it better if they all kind of have a singular mindset of, we all just want to win really badly as a team and want to get better? And maybe even, we're Kobe Bryant, crazy, disciplined people, and that's what matters to us. And I think that we have to allow for the possibility that if we understand diversity is overall a good thing, that doesn't mean it is a good thing every single time in every situation. That's all I got.
Okay, let's let all of the panelists respond to comments of their colleagues. We ran a little bit long, which is fine, but I'm going to ask you to try to confine comments this round to 2 minutes, let's say. Professor Hawkins.
Okay, thank you. I've been writing notes, so I'm going to try to be quick about this. I mean, I think that the biggest thing that I want to say in response to several things that have been said is really to be clear about what I mean in terms of distinguishing diversity from affirmative action. And I might not have said this the first time, so I will say it very clearly here. Affirmative action is not just remedial, but it involves explicit and express admitted considerations of race in decision making. In the case of Weber, for instance, like I said, set asides, right, for Black tradesmen. That's not how diversity works. Not only is it not remedial, it also need not, and most often does not, involve any explicit considerations of race or gender in decision making. Which is the reason why it is highly defensible, because it's not subject to the Weber standard, where you have to prove, right, that you have a justification for making explicit considerations of race. Rather, again, an employee who is challenging a diversity program has to prove that the employer is lying about the fact that while they might care about diversity, they did not explicitly make a decision on the basis solely of race, right? That's not how diversity works. I also want to say that this distinction between the mere fact of race and experience with race that Chief Justice Roberts focused on in SFFA is precisely the kind of decision-making that has always been happening in the employment context in the interest of diversity, because it's been necessary. There has been no express endorsements of explicit uses of race in the employment context in the interest of diversity. So when diversity happens, it happens without any express considerations, at least in the decision-making process, of race. That does not mean that race is not some sort of, useful information, because race is not actually a biological, it's not a physiological, we're not talking about phenotypical race, right? We're not talking about how people look. We are talking about race as a social construct. That simply means that race, all it does is represent our experience as racialized people living in a racialized world. And if, according to Chief Justice Roberts, that is a legitimate consideration that doesn't constitute the consideration of race itself, then to the extent that employers consider that, that is perfectly permissible, and it's not considering the mere fact of an applicant's race. We're not talking about essentializing people on the basis of their racial identity. We're talking about looking at people individually and evaluating what they bring to an individual a job or an opportunity that is unique based on the full scope of their background and experience, which might include, right, a racialized experience. I also want to talk about the empirical evidence. I mean, I think that one of the most often cited articles trying to debunk the empirical benefits of diversity is the Harvard Business Review article from Frank Dobbin and Alexandra Calev back in 2006, diversity best practices or best guesses. And even Frank Dobbin and Alexandra Calev have come back with a rejoinder to all of the kind of, I think, miscitation of that work to try to undermine the empirical evidence of diversity. So in 2022, they released a book called Getting to Diversity, What Works and What Doesn't. And obviously there are ways to do this that are not particularly effective, but there are lots of ways to do it that are. And I think that the empirical evidence is fairly overwhelming at this point. And like I said, the people who have been cited the most for the opposition argument, quite frankly, have been the, I think, the biggest champions of the way in which this can be done well. I think lastly, on the case law point, I think that, you know, Taxman is a very old case. I'm aware of the Xerox cases. In the period that I looked at, which was between 2003, the Grutter decision, and the publication date of that article, which was 2015, I looked at 44 cases across every circuit in the United States. And again, and Taxman, by the way, is a very old case. It's from the 90s. It's pre-Grutter. And so there has been a huge acknowledgement of the legitimacy of the business interest. And we're not talking about Heart of Atlanta. We're not talking about customer preferences. We're talking about businesses recognizing that based on empirical evidence, like Scott Page at the University of Michigan Business School saying, again, diversity of perspective is what contributes to innovation and increased problem solving. But one of the ways in which we can have diverse perspective is based on our lived experiences. And people who are racialized in this racialized society have different experiences, right? And so that is the reason why racial and ethnic diversity is actually associated with, right? It's associated with diversities of ideas and viewpoints, right? And so I think that we have all of the empirical evidence. I do agree that at the end of the day, this may come down to what the evidence says, and it will be incumbent upon the court, unlike in SSFA, to take seriously the record evidence, because I think that a lot of the record evidence was elided by the Supreme Court. Obviously, the district court did not find that there was any discrimination. The district court did not find that there was any kind of stereotyping or improper use of race by Harvard or UNC. And the Supreme Court disregarded that record evidence. So I think that if we're looking at the empirical facts, if we're looking at the record evidence, I think that that will oftentimes be available. And to the extent that the court takes that seriously and defers to that factual record, I think the diversity has a strong case.
John.
So there's much more could be said about, say, the business case for diversity. I want to make one additional point from the SFFA court, which is that the court very squarely rejects the idea that it should, quote, trust, unquote, the universities, trust that the evidence that they marshal is automatically something that ought to be deferred to. The challenge here, and Jay put his finger directly on some of this, is there's an equivocation at times between these different senses of diversity. Are we talking about intellectual diversity? Are we talking about skin color diversity? And the problem here is the practice of using race as a proxy for this business good, like diversity of viewpoint. Race is never supposed to be used as a proxy. That's one of the upshots of our civil rights laws. I want to, I know it's a bit scattershot, but questions that I also wanted to throw out there. Interested in if Jason has a response. First Amendment argument. I'm curious if, in his view, that ever puts a limit on Title VII, or if that's completely distinguishable. Also curious if the expressive association rationale could ever implicate defamation liability. Like, I'm thinking of, like, the Coral Gables case is Amazon, I believe, relying on the Southern Poverty Law Center and its politically disputatious enemies list that the SPLC, and like, could Amazon potentially be liable if SPLC were found to be defamatory? Last, I want to make we talked about the kind of the countervailing pressures that Jay mentioned on companies. A possible third way out is a very modest proposal, which is, of course, one of race blindness. SFFA hints at this with its discussion of the arbitrariness of racial classifications and categorization, building off of the work of David Bernstein, Professor Bernstein at Scalia Law School, in showcasing how these categories we tend to take for granted get their crispness really in the bowels of the Office of Management and Budget, starting in the 60s and 70s. I'll end with this note. I think I've got some good authority for this notion that maybe classification is not appropriate. The first Justice Harlan, in his rightly famous Plessy dissent, says in that dissent, in respect of civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. I would love to see that concept develop further, and I think some ongoing litigation will do just that.
Jason.
Great stuff. So, all right. So I will heed the judge's instruction. There's no red light, but I'm going to try to keep my my comments very brief. So 3 things I want to talk about. Johnson and Weber, and I think Judge Katsas, you alluded to this in your introduction. If and when they make it back to the Supreme Court, I think everybody would agree, if you read Johnson and Weber, that mode of analysis is not the mode of analysis that the current Supreme Court uses. So put aside whether you agree with it, disagree with it, whether you think it's right or wrong, the viability of those cases, I think, is at risk, right? If and when that defense makes it back to the Supreme Court, unless there's just some deference based on stare decisis, right? I don't think that's the end all be all here, because all of the programs that we're sort of lumping into this bucket of corporate diversity programs, there's a wide spectrum of stuff that fits there, right? Some of which is geared more towards what I'll call the essay type approach, meaning consideration of a broader definition of diversity that is not anchored in race or gender or protected criteria. Others of which might be anchored in that way, but don't rise to an actionable level. And then others of which are designed to ensure non-discriminatory decision-making, right? Like a lot of the statistical analysis and goals and programs along those lines are not designed to drive decision-making based on race or gender, but if they're done well with good labor economics behind them, they're designed to be a check and balance to ensure that the system is operating in a non-discriminatory way, right? So there's a lot of stuff going on here, I think, that shouldn't be grouped all in one analysis. And then last point, I'll take Judge Berry's questions with respect to the First Amendment. So number one, no, I don't think the First Amendment has nearly as much force in the employment context. And I think everybody would agree that as compared to charitable giving or investment, employment decisions are not going to be subject to well, this is an expression of my First Amendment belief about a particular race or whatever. I think that's a dangerous road, and that's not something that I'm advocating. I think the employment analysis is different. And then with respect to defamation, I don't think so. In other words, would somebody be subject to a defamation claim because they've chosen not to support a particular charity because they'll say that charity has views that I don't agree with? I actually think that's the core of the First Amendment argument. I can give my money to whoever I want to in order to endorse a view, to oppose a view. I might even be mistaken about what statement I'm making with my money. But all of it is a protected First Amendment exercise. And so that, too, I think is a dangerous road to say, well, if you decided not to endorse this cause, it's because of, some maligning reason. I just don't think that's a productive analysis for courts to get into. You can speak for whatever reason you want to support or not support whatever idea you want. And that's why I think this type of charitable giving is protected. So.
Okay, Jay.
Two very quick points. One is I definitely agree with the notion that courts are going to be looking under the hood a bit more and not trusting when employers say, for example, what we're looking for is diversity of viewpoints, and that they're going to look for more information. One thing that's I think going to be difficult is the best place to look is to the DEI groups, the corporate DEI groups within those companies. And, one interesting question is, if the commitment is to having different types of people who think differently about it, and that's what you care about as opposed to remediation, well, what do your DEI groups look like? Do they all look the same or not? And I would counsel employers to think about that. And then I also just want to mention one thing, because whenever I talk about these issues, someone will bring it up later on, which is, well, you guys are kind of more of a lefty firm than others. Do you actually believe in intellectual diversity? Like, for example, you're speaking at FedSoc, but does that mean you would welcome applications from people in FedSoc? And the answer is, of course. That's one of the reasons I speak on these panels, because people have different views and I've learned different things from it. So to any FedSoc people out there, don't be shy of our firm, or if you are, don't be shy for that reason.
All right, we have time for a couple of questions, so I'll just try to synthesize what I'm getting here. So, seems to be general agreement among the panel that a diversity rationale is more promising than a old style remedial rationale. So let's focus on diversity, and let's assume that the court elides the approach, the equal protection and Title VI approach from Harvard to things like Title VII in 1981. So on those assumptions, this just would seem to come down to the difference between higher education and employment. So Professor Hawkins, or whoever has a view on this, are there any differences in the various diversity arguments in those respective contexts? And I'll be a little bit provocative and just throw out the idea that, maybe the diversity rationales would have been stronger in the context of universities, with thoughts about diversity of ideas, maybe correlating to race, versus staffing up the sort of blue collar projects at issue in cases like Weber and Johnson. What's the huge diversity interest in who's jackhammering on the highway? So what are the differences? What are the different arguments, and how could you construct a view that the employment context has diversity rationales more that are stronger than even the higher education rationales?
So let me start by acknowledging something that I've already said, which is that I agree that Weber and Johnson are, for the most part, a dead letter. I said that at the outset. But what is also important is that I also said that workplace diversity efforts, though, don't depend on Weber and Johnson. They're not really, when they're done properly, adjudicated under Weber and Johnson, right? So the kind of dead letter of Weber and Johnson is not fatal to contemporary workplace diversity efforts, assuming that the court were to reconsider and overrule Weber and Johnson. That would be no, a concern for contemporary diversity efforts. I think that there are lots of, and you're right, they're going to be different in some respects, the same in other respects. But I will tell you, and again, I alluded to this at the outset, I don't think it's insignificant that even in adjudicating the interest in student body diversity in the higher education admissions context, the Supreme Court in Grutter cited to the interest of major American businesses who had, by the way, submitted a record number of amicus briefs in support of the University of Michigan in that case, demonstrating, right, that they really were the downstream beneficiaries of this student body diversity, and that diversity was critical, right, to their operational success. And I don't think that the Supreme Court discounted that. In fact, I think that they took that very seriously in arriving at the conclusion that diversity could be a compelling interest on behalf of colleges and universities, precisely because their end users, employers, right, said that it was a critical interest for them. That being said, to go back to Mr. Berry's comment about the kind of empirical reference and the court in SFFA saying no deference. Well, we do know that under the First Amendment in Grutter, the court had applied a more deferential standard to higher education institutions than they would ordinarily apply, right, to the record evidence. But that has never been the case in the Title VII context. But there is, I think, a parallel level of deference under Title VII where the court has said, we're not going to sit as a super personnel agency, right? Second guessing every decision of an employer. That is the reason why in McDonnell Douglas, it is simply, right, a burden of production. It's not a burden of proof, right, to proffer a legitimate non-discriminatory business reason. But to the extent that there does have to be some empirical support, I do believe that there is overwhelming empirical evidence in support of the business case across a range of different justifications for diversity, not just the kind of, innovation and what you would call intellectual or epistemic benefits of diversity, but also the benefits that accrue in terms of the kind of cultural competence. So for instance, I think, Mr. Schwartz, I think it was, no, it was Mr. Edelson, I'm sorry, made this point when he talked about the NFL concussion settlement and the fact that these white lawyers had constructed this settlement that was race normed, and it was the Black lawyers who had to come in and look at that and say, wait a minute, right? And it's not just because of the mere fact of their race, it is the fact that their experience, right, as racialized people in a racialized society gave them the insight to know, to question that assumption, right? And that's what we're talking about. And so I would say that, again, assuming that the kind of race neutrality as Chief Justice Roberts described it in SSFA, which is you may not consider the mere fact of race, but experience with race is fine. If that is permissible, that is precisely what employers who have been engaged in diversity work have been doing. And if that is what's going to be adjudicated, I think even under SSFA, that stands a strong chance of endorsement.
Anybody else?
So just briefly, we have a lot of examples that are produced like across these suits of employers using race at employers or institutions of higher education using race as a pretty blunt instrument, as a reductive, crude proxy, standing in for the things that are claimed for people to actually care about. What I guess I don't understand, and more importantly, don't see warrant for, given the SFFA decision, especially, is use of race as a proxy for the goods of operating business that are uncontroversial. Whether it is something like cultural controversy, cultural competency. Sure, cultural competency is correlated, maybe even highly correlated with race, but it is distinguishable from these things. And that's something that we can be aimed at directly. Creating a team in the workplace with the right diverse set of skills and interests is absolutely something that an employer can do, again, without bringing in race as a proxy. I don't see any warrant, given the direction that the court has signaled, that there's going to be any real tolerance for an expansion or even application, really, of the diversity rationale.
Anybody else? All right, I'm going to try to squeeze in one more question real quick, which is nobody took up my teaser on Bostock, so let me just try again. In that case, the Supreme Court said pretty clearly that it violates Title VII if the employer treats an employee differently, in part, and I want to emphasize the in part, because of race or sex. Now, a lot of the defense of race-conscious hiring in the university cases has been that the universities look at race, but it's not only race, it's a factor of a factor of a factor in a complicated, holistic process. Whatever the merits of that argument for purposes of equal protection, strict scrutiny, it seems awfully hard to reconcile with the rule distilled in Bostock. So anyone, any takers on that?
I'm gonna, Judge, I wish I could answer your question more directly, but I want to answer it this way in a more practical way, which is employers are in a lot of ways dumber than academic institutions. So what you're going to see is trying to figure out what was going on with academic institutions. They're able to hide it better. What we've seen is very sophisticated companies do things like saying, we want to fill this role and it is going to be a Black woman. And when you have those types of cases, those likely are going to be front and center before we start answering these other questions, which I think still it shouldn't be hard to guess where the Supreme Court is going to come out on this. But I think those are going to be a lot of the first mover cases.
And I would say that may exist. I'm not going to deny that it does, but I would say that that's not necessarily emblematic of what's going on across the board, just like there are companies that are still being held liable for traditional discrimination because they are engaging in outright, racial or gender discrimination. That doesn't mean that, discrimination is rampant across every workplace, right? So yes, are people engaged in, lazy diversity efforts that don't take into account, more than the mere fact of an applicant's race? Maybe, but I don't think that is emblematic. And this is what I will say, Judge Costas, about your question. I think that one of the things that, again, Mr. Berry said is using race as a proxy. One of the reasons why colleges and universities were using race as a proxy is because the nature of the admissions process is a high volume game about making thousands of decisions at a single decision point out of tens of thousands of applicants where people are not individually interviewed, right? We don't really know a lot about these people. We don't have an opportunity to engage with them personally and understand what their experience is, except through the bland paper application. And so colleges and universities were permitted to use race as a proxy because that was an effective mechanism for getting at what they really wanted, right? Which was diversity of experience. Employers don't have to rely on the proxy. They do, right? Meet with every applicant that they're going to offer employment to. They are able to make more individualized assessments of people on the basis of their actual experience. And so they need not, and they should not, and in my experience, they are not using race as a proxy.
Okay, we are a little bit over, so I'm just going to thank our panelists for an excellent presentation and turn the floor back to Alita.
Thanks, Judge, and thanks. I agree. Thanks so much to our panelists. On behalf of the Federalist Society, I want to thank everyone for participating in this program, our panelists, our fantastic moderator, and our audience for the great questions that came filtered in through moderator questioning. We welcome listener feedback by email at info@fedsoc.org. Please keep an eye on our website and especially on your emails for announcements of upcoming virtual events, especially the next events in our series where we will actually do more of a deep dive into the Muldrow terms and conditions of employment job transfer question, as well as many of the other tantalizing little hints that were dropped in the course of the discussion today. Thanks again for joining us. We are adjourned.